Hi, my name is Peter Altman from Akin, Gump, Strauss, Hauer, and Feld, and my one big thing for Securities Enforcement Forum West 2020 is the effect the COVID-19 pandemic has had on the amount of material non-public information presently in the U.S. securities markets. On March 23rd, the directors of the SEC's Division of Enforcement issued a statement emphasizing the heightened risk of unlawful securities trading during the volatile circumstances created by the rapidly changing economic times we are all living through. From political intelligence regarding legislative and regulatory developments to changing financial forecasts and guidance by public reporting companies, MNPI permeates throughout today's markets. Market participants need to show increased vigilance as a result when evaluating the content and sources of information they receive before placing securities trades. This is particularly important given the fact that we are all dispersed in our work-from-home environments these days.
Welcome back. This next panel is on cybersecurity. And of course, in honor of the 3 LA people on the panel, I've switched to Beverly Hills from San Francisco. The cyber area has multiple angles of securities regulation relevance. So these are very challenging issues. There's a lot of gray areas such as disclosure, requirements for SEC registered entities, insider trading, and a lot more. We have a great moderator for this panel. Peter Altman is a seasoned pro on securities enforcement. He's a partner at Akin Gump, who also previously served in the SEC's enforcement division. Peter manages a broad array of SEC matters. He leads the defense of SEC, CFTC, DOJ investigations. This is critical in the cyberspace because each federal agency might in fact have a different view or approach to cybersecurity. But Peter is also an expert on how registered firms should manage client privacy and data security. Peter, thanks so much for moderating and welcome.
Thank you, Bruce. Good to be here.
Also very pleased to introduce John Barry. John's a partner at Munger and a seasoned litigator himself, having litigated 26 cases to summary judgment and argued more than 40 dispositive motions and appeals in federal and state trial and appellate courts. John was previously an associate regional director in the SEC's LA office, where he co-led that office's enforcement staff. And he also previously served as regional trial counsel, which is a rare combination, a very useful combination of experience. Welcome, John.
Thanks, Bruce.
I'm very pleased to have Brent Wilner with us. Brent's a member of the SEC's cyber unit, and that unit has pretty much enjoyed an undefeated record, at least lately, racking up win after win. Brent is also a former deputy AG in California. It's really nice to have a senior member of the cyber unit on this panel to provide a frontline view of the field. Welcome, Brent, and thank you for being here.
Thank you, Bruce.
Finally, Ken Joseph is now managing director and head of Duff & Phelps Disputes Consulting Practice. Ken actually has 2 specialties. He worked in the Office of Compliance, Inspections, and Examinations, and also as a senior officer in the SEC's Division of Enforcement as the co-chief of the Asset Management Specialized Unit. So that's, again, a very valuable and unusual combination, quite helpful for this panel in particular. Welcome, Ken.
Thank you, Bruce.
All right, I'm very pleased to turn it over to Peter.
Thanks again, Bruce. This is really a terrific collection of panelists. Tried to do something a little bit different with today's panel, and we've structured our discussion around a hypothetical scenario involving a cyber intrusion and the cascade of issues that flow from it. We'll provide some experiential tales, lessons learned, and tangible takeaways along the way. For those of you in the audience, whether this is your first panel of the day or you've been attending some of the other great sessions, please feel free to send questions along the way through the chat function, and we'll try to address them during the panel. So let's jump right into the hypo. So Padlock Holding Company, which we're going to refer to as Holdco today, owns Padlock Bank, a leading global financial services firm. Shares of Holdco trade publicly, and it's an SEC reporting company. Padlock Investments is another subsidiary of Holdco that provides investment advisory services, and it's registered with the SEC as an investment advisor. Padlock Investments is responsible for approximately 30% of Holdco's annual revenue. So, in sum, we have a public reporting company and an SEC regulated entity. And the padlock, so to speak, is about to be opened. Cue the, During the on-site portion of Padlock Investments' most recent SEC examination, an examiner asked Padlock Investments' chief compliance officer about a series of entries in the firm's annual review document, which the CCO had finalized the week prior to the exam. The entries related to identified risks regarding the maintenance of user account credentials for advisory personnel. CCO had not had time to follow up on the issue as the announcement of the exam interrupted his normal workflow. The CCO tells the examiner that he'll have to circle back to him on this the following day. That evening, the CCO meets with the firm's information security team, who quickly identifies a significant amount of activity associated with the user account of Padlock Investments' former controller, who had left the firm 6 months earlier. The initial triage data also suggests some anomalous cash transfers out of client accounts in the preceding 36 hours. And oh, by the way, the former controller also had full access to Holdco's financial reporting tracking system. A real mess. So, our first topic for today is kind of what should be done in the first 24 hours after you figure all of this out, or at least you figure this initial part out. So, John, the SEC's examination function has released a lot of guidance regarding cybersecurity over the last few years, including cybersecurity and resiliency observations this past February, which I know may feel like a very long time ago, but is rather recent. And it was the latest in a series of risk alerts and other guidance in this space from OC. So thinking about the hypo, John, what do you tell the SEC examiner the next morning when they return for the continuation of the onsite? Do you alert them to the existence of this security incident?
So this is, Peter, this is a good hypo. I don't think anybody else on the panel endorsed your padlock joke, but we'll go with the hypo. The hypo is good because it's like your worst nightmare. You've got a discovery of a cyber incident. The same time you've got SEC examiners in your office. And so it's sort of a double whammy, and trying to figure out whether or not or when to talk to the SEC examiner about the cyber incident while he or she is in your office is a very tricky issue. I mean, in the first step, like anything, is going to be trying to figure out, well, what's Padlock's exposure here? And for cyber incidents and investment advisors, there's some key regulations. As you mentioned, there's some definite guidance out there. OC at the SEC, the examiners at the SEC are definitely focused on cyber. When you look at their priorities that they've been issuing in 2019 and 2020, cyber ranks right at the top of the list as things they're looking at. They're the priorities for each one of their programs. So they are definitely focused on it. So if you have an examiner in your office examining your books and records and examining your advisory functions, they're definitely going to be asking you about it. So if you find out there's a cyber incident, you really got to stop and think about it. And there's sort of two regulations that come into play if you're thinking about cyber incidents at an investment advisor, and that's Regulation SP and Regulation SID. Those are probably the most prominent ones. So, Regulation SP, that's called the safeguard rule. That's the one that obligates investment advisors to protect customer data and accounts and PII, personally identifiable information. And then there's also Regulation SID, which is the identity theft red flag rule. And both of these rules have been around for a while. The Regulation SID is really there to make sure the investment advisor is detecting and identifying red flags of identity theft. And so when you think about those rules and whether or not they actually are implicated here, you can think about the two preeminent cases that the SEC has brought under these rules. And one was against Morgan Stanley, and the other one was against Voya Financial. And in both of those cases, you had incidents where there were breaches. And in Morgan Stanley, it was actually an employee downloaded a bunch of client account data on his own computer, and then he was hacked. And in Voya Financial, they had actually cyber attackers impersonating employees to reset passwords to get access to the information. And in neither of those cases was a client account money ever lost. Yet the SEC fined both entities $1 million for violating these provisions because the SEC, because they're so focused on it, and they believe it's so important to make sure investment advisors are focused on it. So when padlock is sitting there and they've got the examiner coming the next morning, they need to be thinking about these two rules, and they probably apply here, right? You've got a controller who left 6 months ago. According to the hypo that Peter read, that the IT staff was quickly able to identify these issues. So maybe there were some clear red flags here of what the controller was doing. So that would implicate Reg SID. And then Reg SP, the one that the safeguard rule, he's clearly breached. It sounds like he's breached into the client account. So you've got those two rules at play immediately. And because he was Padlock's controller, you certainly have some of the anti-fraud statutes that apply to the investment advisors. So there's exposure here that you're finding out the night before, and you got to figure out if you're going to tell the examiner the next day. And you could say that when you're confronted with issues like this, it's not that much different when you're doing any kind of internal investigation, right? When you're doing an internal investigation and you're finding out that there might be some misleading disclosures at your company or some other kind of fraud, one of the first questions you ask is, do we tell the SEC? And often people do. As painful as it is, it's sometimes better, especially if you've got OC examiners who clearly are focused on cyber issues. It's probably better to tell them before they find out. But this, with cyber incidents, it's a little bit trickier because the speed in which these things happen, and the fact that you're going to definitely possibly have not only the SEC, which is your regulator, which is Padlock's regulator, coming in to trying to find out if the regulator, if the Padlock did something wrong. You probably, Padlock may be considering talking to the criminal authorities, and the criminal authorities are going to have a completely different agenda of trying to figure out if trying to find out who did the wrong rather than trying to find out if Padlock did anything wrong. So there are a lot of competing considerations. Time is not on your side. And I think the only other thing to add, Peter, is that I think it's something like this just highlights why it's so important to have some kind of incident response plan in place that's been played out and practiced upon. Because when the event happens, you've got 24, 48, 72-hour window to react. And if you haven't practiced that out, you're going to be confronting these and a host of other issues you're going to have to figure out on you right in the spot instead of having to try to predetermine them. But I think it could be that you're going to be telling that examiner the very next morning this happened without having much of an idea of the scope or breadth of the problem.
Yeah, that's a great transition, John, in terms of talking about incident response. So Ken, in a scenario like this where you unexpectedly stumble across what appears to be really a massive security incident, but you don't have a handle on the scale or the scope of this, that next morning you've been up all night with the security team, you're scrambling around trying to figure out what to tell this examiner who's got the annual review in their hands. What are your kind of first three steps? It's 7 a.m. on day 2. What are your first 3 steps? Does one of them include contacting criminal law enforcement like John referred to?
That's a truly it depends response, Peter. I think in addition to evaluating the legal and regulatory and / exam exposure, by the way, on the facts that you presented in the hypo, the compliance program would be called into question as well, because it looks as though the CCO at least is on notice with regard to some pre-existing issue and may not have acted in a timely fashion, probably causing some exposure to the client assets and information, so implicating the custody rule as well. But putting that aside, after you've assessed or begin your assessment of the legal and regulatory exposure, as John mentioned, I think it's time to dust off that tried and trusted incident response plan. At 7 o'clock in the morning is not the time to start formulating such a plan. Hopefully it was in place and properly tailored to in light of the risk that the entity has faced. I would also engage right up front outside counsel who, as part of the incident response, and make sure that you formulate a team of various types of professionals who would be able to both investigate what's going on, preserve the data and the logs and so on that would be necessary to investigate what's going on, to deal with the crisis communications and crisis management that may occur as a result of this, and of course, engaging disclosure counsel as well to determine whether there's any disclosure obligation that is created here. I haven't mentioned yet the IT team, also supplemented by the outside forensic teams that would be crucial to finding out whether this is an isolated breach and whether, in fact, it's an ongoing issue that needs to be responded to and plugged almost immediately. So all of those scenarios in a well-constructed incident response plan, you try to anticipate what your response would be given various assumptions.
So maybe one other might be starting to think about it, notifying any applicable insurance carrier you have too.
Correct.
Someone's going to have to pay for all of those advisors.
Yeah, you mentioned the point of whether you notify or engage law enforcement. I think that is also, it depends clearly with the examiners on site. Given that cooperation is a huge issue and that's judged in hindsight, I think you want to think long and hard about disclosing what you know, even if that story is incomplete. At this time, you didn't have enough time to investigate fully. You at least want to let them know that there was an incident, and because they'll find out at some point, a high likelihood, especially if client assets may be involved. And you want to err on, I think, on the side of disclosure. The larger question for me is whether you call the FBI or your local U.S. Attorney's office, and that truly, it really depends on the nature of the threat. If it's an ongoing issue, somebody's life is threatened, if there's malware or ransomware at issue, I would err on the side of involving external law enforcement here.
Right. Another flawless transition. So Brent, for many years now, we've heard this refrain at conferences or other kind of PSA style statements, and it's typically from criminal law enforcement, but I think also from civil regulators, that companies really should feel comfortable to quickly report cyber breaches to the government in order to facilitate efforts to capture the bad actors. And I think the DOJ, FBI in particular, sort of encourage people to develop relationships with their local field office so that it isn't the first time you're necessarily contacting them. I think a lot of people, though, struggle with kind of the why here. And in other words, sort of what is really in it for people to cooperate with the government. And so why don't we just focus specifically on the SEC here. In this scenario, maybe just twist the hypo a little bit and have it not be with an exam going on, but just generally, what's kind of in it for an SEC registrant to cooperate with the SEC when faced with a scenario like this?
Yeah, thanks, Peter. And I think you did a great job with the hypo, so I appreciate it's a good launching point. To start, for probably the 8th time people have heard it today, I want to give the standard SEC disclaimer that the views I'm about to express are my own and not necessarily those of the commission or the other staff. Before I dive into sort of specifically thinking about why Padlock should or shouldn't reach out to the SEC and sort of what's in it, I think it's helpful to start with the big picture, which is that we understand, this is, speaking from my experience working in the cyber unit, we understand that cyber incidents can be traumatic, even existential events for issuers and registrants. So we understand, all of the activities that Ken just described are going on. There's a flurry of activity. With that said, it's still firmly our expectation, as has been sort of articulated by the Commission and enforcement actions and also in the 2018 guidance, that whether it's an issuer or in the case of registrants, that that securities law compliance will be part of that response thinking. We'll sort of leave to the side for a second whether in this particular case those would be implicated. But I just think big picture, that is our expectation, and the SEC, we have a role to play in cybersecurity incidents. So how is Padlock? How does a company like Padlock, or how does the investment company think about whether it's in their best interest to sort of initiate interactions, say with the enforcement division? I think from an enforcement division perspective, I think it's important to think how we in the cyber unit and sort of more generally have been approaching enforcement, and hopefully that will sort of give some comfort, some guidance for entities to think about what the right steps are. So there's really two parts of our program that are implicated by the really good hypo, and John Barry kind of already alluded to them. There's the registrant side, the investment part of Padlock, and there you're dealing with controls at regulated entities, which are required to have cybersecurity related controls under the relevant regs here are SP and SID, and John sort of laid out what those regulations entail. And then you have the public company side, the holdco side, and there, our program has been very active in looking at disclosure obligations as well, and we'll talk a little bit later about maintaining adequate internal accounting controls in light of known cybersecurity risks. And so our general approach in enforcement in both of these areas has been to avoid second-guessing good faith decisions. So for regulated entities, the rules don't require perfection, and so we're not looking to upend reasonable conduct. For public companies, for the holdco part of the hypothetical, we're tasked with ensuring compliance with the disclosure requirements, but we're mindful that companies like holdco are victims of a crime, and that weighs on our review. So it's not, I know that sometimes people worry that those are just words that we say, but I think this measured approach is really borne out by our enforcement actions. From my perspective, our cybersecurity actions to date have involved egregious fact patterns. John sort of already alluded to a couple of them. I would say the Voya matter is really on the far end of the spectrum in terms of SP and SID violations. If you look at the order, it sort of lays out a host of things that really went wrong. And similarly, on the disclosure side, our two sort of relevant cases on point, the Yahoo matter and then the Facebook Cambridge Analytica matter, those are situations that involved an extreme dereliction of their obligations under the securities laws. So, we're not expecting to bring dozens of cases in this area, although we envision bringing cases when there are clear violations. And hopefully that's a transition point for a company like Padlock, or for whether the holdco or the investment part of Padlock, to think about how to approach us. Our hope is that this measured enforcement approach encourages firms to feel comfortable taking a collaborative approach with the agency. And I get that still sort of leaves out, which is sort of the big kicker of your question, Peter, which is, what did they get, right? Ultimately, the facts are going to dictate whether there's an enforcement issue. But if the firm handled an issue reasonably, I think as borne out by our enforcement actions to date, we're going to recognize that. On the other hand, if the facts are bad, trying to hide them from the SEC is not a great strategy. One last sort of sub point I'll put on this hypothetical. I think Ken and John both alluded to the existence of other regulators. I think that's a particularly apt observation here, where you sort of have a company that has probably a lot of regulators that will be kind of mixing in this pot. We work well with other regulators. I think it's something we do. And whether it's something that's sort of motivated by our staff kind of initiating the contact with the other regulators, or whether someone like Peter or John's firm, I think it's totally appropriate to sort of acknowledge that and point that out to the SEC staff that you're dealing with. And that way, hopefully that can limit the duplicity and sort of the extra burden that sometimes feels like when you're having to respond to multiple regulators.
So great perspective, Brent. John, go ahead.
Yeah, one thing I think I want to jump off what Brent was talking about. One thing that makes this hypo so complicated is that it appears that this cyber attack was from a former insider. A lot of times cyber attacks, you're dealing with third parties somehow infiltrating your system through whatever types of scams, business email scams or what have you, to come into the system. And you can find a company who's subject to such an attack. One thing they're dealing with is the fact they don't know the scope or who's doing it or why or when they did it. That's what makes this hypo, I think, more complicated, is because all indication is it's a former key employee who recently left. And so there may be a sense if you're advising Padlock, thinking, well, maybe we can try to figure this out on our own without getting the government involved. And one reason that could be driving that is because it's a former controller, there's added exposure, right? If a former controller was doing something wrong with client accounts, that creates potential liability for the entity as well, which could make the Padlock, whoever's advising Padlock, think twice about wanting to go to the government really quickly, because unlike maybe a third-party cyber attack where the government may be more willing to stand back and let them and be less or more reticent to ping the investment advisor and charge them, when it's a insider as high as a controller doing it, the SEC may have a reason to go after the investment advisor harder than they would in, say, another kind of cyber attack.
Right. Or of course, John, it could be that some external threat actor has taken over those user account credentials and is taking advantage of the access that person had.
Sure. Yeah.
My one takeaway for everyone out there might be, now that you're at home working, it's a good time to think about your password hygiene and do some resets. So in any case,
there's an additional scenario there. Even though, we're focused on the former controller, you have no idea at this point whether there may be current insiders who may be working as part of a broader scheme as well. So that has to be evaluated as part of the response.
All right, so a lot to consider between 7 a.m. and 9 a.m. when the examiner comes back in for day 2 of the on-site. Nice long checklist to work through over your probably 7 cups of coffee to get going.
Peter, we haven't mentioned it specifically yet, but I think it's also important that the CCO who is engaging with the examiners on site isn't doing so without having escalated the situation through the corporate chain here, involving internal counsel and the front office, if you will, to at least let them know what the potential issues are, even if it's under development, under investigation.
So just in the interest of time, we're going to sort of push ahead in the chronology here and think about sort of some ways where with this hypothetical, there could be ways to try to avoid making this bad situation even worse. And so, Ken, let's suppose that your firm is brought in to consult on this matter, perhaps by outside counsel like Munger, Tolles, or Akin, Gump. And in the course of the investigation, it's discovered that the entry point to Padlock Investments user credential database is actually some third-party vendor that the firm uses. And let's further assume that in order to remediate this issue, Padlock needs to alert all employees of Holdco. Remember, this is a very large organization with a bank, an investment advisor, that they all need to go out and change their password. And the company also needs to take its servers offline for a time to install some additional security patches. Ken, what considerations should Holdco consider when it takes steps like this? How much detail, if any, should management be getting into with its employees about what's going on?
So a number of issues you raised there. The vendor third-party management issue, which I'll come back to. But the crux of the question really is around how much do you disclose to insiders and what their duty of confidentiality would be. I think because of the natural concerns over possible misuse of that information, insider trading purposes, you have to communicate that there was an issue, but at this point you don't really know what the extent of that issue is and what the potential full set of implications are. So I would advise that any communications be limited enough to protect the sanctity of the investigation that you're going to have to do, protect the sanctity of the confidential information that, again, has the potential for being misused, but enough to take preventive steps to the extent it's an ongoing issue to alert the end users, if you will, that there is an issue that the firm needs to fix.
So John, Ken alluded to this. This is, obviously highly confidential information. information that could be of interest to outsiders out there in the market. Does this raise the threat of potential insider trading by company employees? And just before you answer, perhaps the obvious point here is or the obvious question would be: is the threat even more acute with, let's just assume this is a company where everyone is working from home? It isn't a manufacturing type of situation. Like I said, it's a bank. Everyone is working remotely, and you have people spread out all over the country. Is there additional care that you might want to encourage the company to take regarding the dissemination of information around this cyber incident? Should the CEO be getting on some huge Zoom call and be broadcasting it out, or should you be thinking a little bit more carefully about it?
Yeah, you got to be careful here, right? Because insider trading is definitely already a threat, right? You assume that this kind of breach by the controller of the investment advisor getting access to client accounts is already a big deal, and so anyone knowing that information could have an incentive to sell. You saw that in the Equifax case. Back in 2017, Equifax had a breach. It's a company whose main purpose is to keep data confidential, and it got breached. And they had the CIO of the company caught insider trading because he knew full well about it. But they also, what's interesting about that case, which I think applies to this situation, they had an IT specialist who also insider traded. Now, while the CIO was fully aware and was in the loop of what was going on in the plan to deal with the breach, the IT specialist was not. And what they did was they told the IT specialist, sort of duped him a little bit, said, hey, we're working on a remediation plan for a client. And so they had the IT specialist think that maybe that it had nothing to do with the company, when in fact it did. The IT specialist ended up figuring it out and then insider traded. And I think that case shows the dangers of piecemeal dissemination of information about the breach, right? Even people who they tried to shield from the information, like that IT specialist, ended up trading. And the problem was because they tried to shield him, he was not part of any blackout programs or anything like that. So one takeaway from the Equifax case you could have in a situation like this is be careful how you disseminate it, but by disseminating it, when you do that, you make sure those who are receiving the information are part of your blackout programs and making it very clear and sending out reminders like you cannot insider trade. Because when you do what they did in Equifax and trying to have only a limited number of people who were part of the blackout program and then leaving most of the company out of it, you open up yourself to having a host of people who could find out just through rumor mills and water cooler chatting of ended up insider trading and not be subject to blackout periods. But you raised, Peter, an excellent point. In this day and age, trying to figure out the right kind of internal communication that can be controlled is very tricky. This happens all the time with internal investigations, right? Good leadership will want to make sure they communicate and be open for morale purposes and to avoid the rumor mills. But in this day and age, when you're doing that by Zoom or by email, a lot of that can be recorded or easily forwarded to people maybe you didn't want to get that information. So it's a very tricky issue. It's more tricky now, to answer your question, I think, than it was, say, 6 months ago.
Yeah, I think striking the right balance between what you disclose internally and what you need to do in order to not only determine the extent of the problem, but to fix it is a very important balancing act. I could remember, we're in the midst of an investigation here trying to determine what happened, how many accounts are impacted, what the extent of any vulnerabilities that have been exploited here is, who else may be involved. And we have document and logs and other forensic data that needs to be preserved. So the more broadly you disseminate that information internally is, I think, the higher the likelihood that either an insider trading exposure is created or it somehow compromises your ability to do a proper investigation in a timely fashion.
And because this is an investment advisor, you've also got the complicated issue, you've got clients out there. right?
Yeah.
And so when you disseminate this information, you got client reps who now find out their 20-year-long client, may be subject to a breach. They're going to have their own incentives to want to message it the way they want to. So it's even more complicated by the fact that you've got to breach an investment advisor and how to internally communicate this.
All right, so Brent, we've obviously heard a lot about potential insider trading. A lot of the speakers today featured insider trading in their kind of one big thing for the conference. Steve Pekin called it out, his prior comments along with Stephanie Avakian. I think we can all sort of understand that the SEC is going to be all over trade surveillance right now. What about another sort of angle of insider trading? I'll just call it broadly. Over the last few years, we've seen cases from the SEC involving threat actors basically weaponizing stolen information and trying to use it to trade advantageously. Is that something that the SEC is continuing to look at, especially like in this day and age?
Yeah. So just stepping back for a second, I mean, illegal trading is certainly a priority for the cyber unit, and there's really two prongs to that. There's I think what sort of John and Ken were more focused on, which is trading by insiders who are privy to this information about a breach. And then there's the sort of threat actors that you're referring to, which are cases essentially where a cyber crime has been committed for purposes of obtaining MMPI. And they are both sort of an active focus of the cyber unit. And, as you sort of alluded to, given the unfortunate circumstances that are created by COVID-19, I think, we're fully aware that this is a risk area that's only gone up. Let me just touch for a second before I go to the threat actor point on sort of the first prong, because I want to pick up and echo some of the comments that John made. And I think he did a really good job of highlighting, what sort of makes, I think, these cybersecurity incidents and sort of the disclosure obligations around them, what makes them very ripe for potential insider trading. And it, at a high level, right, the commission has made clear that there's an expectation that companies have in place policies and procedures that protect against this. And I think, both John and Ken sort of did a good job of articulating sort of the types of things that you need to think about when you're adopting those policies and procedures. But really, I think, the case that John pointed to, the Equifax case, in which you had an employee who was not specifically told the MMPI, but was sort of able to glean it from this sort of accumulation of information he did have. I think that's a very sort of unique aspect of the insider trading cases that we sort of see in this space, right? Which is you have a really diffuse amount of people that potentially get access to the information. It's not just like a merger and an acquisition where you're sort of able to keep the information locked inside of a pretty tight. Even more diffuse than sort of some of the insider trading cases we've seen in advance of earnings releases, right? So, in advance of the panel, one of the things we were talking about is this notion of like, what do you do in the case of a ransomware, right? Where there's sort of been a disruption in the company's service. You potentially have even the lowest line level employees sort of observing the effects of the cybersecurity incident before, potentially before senior management gets wind of it. And so I think that presents some really challenging issues that I think we just sort of are sort of hoping that public companies are thinking through when they're crafting their policies, just to sort of be mindful of how unique that is. To the second part of your, to your question, 100%, hacking and other cybersecurity breaches for purposes of obtaining MMPI is an active focus of ours. You have, a real wide range of threats. You have both sort of the internal type of threat that I think your hypothetical does a good job of articulating. And then unfortunately, and of course, you have a wide range of outside actors that you could be dealing with. And that can go sort of from the unsophisticated actors, right? The sort of, the low level hackers, if you will, all the way up to sort of nation state intrusion. And I think, our cases that we brought in this space, I think they show kind of sophistication of our ability to detect that type of trading and to piece together really, really sort of amazing cases that I think show the quality and sort of the expertise that our program has. I mean, I think my favorite one that I point to, and this is going back a couple of years, but sort of the ring of trading, where there was hacking of PR Newswire releases sort of in the minutes right before the release was actually issued, and then there would be trading sort of based on that preemptive information about the release. There are obviously some interesting questions in terms of, does this fit neatly within insider trading law? But I think, as we've shown, whether it's a classic insider trading case or not, it certainly is something that falls within the boundaries of what we consider to be securities law violations, and we're able to aggressively pursue it.
Yeah. Hey, Peter, if I could just follow up on one thing there. According to the fact pattern here, the vulnerability occurred, at least in the first instance, at the vendor level. And I just wanted to make a point here with regards to the importance of making sure that those vendor contracts, the whole vendor management space, if you will, anticipates what the obligations of the parties are in situations like this. There ought to be a cooperation clause, a notification clause in those vendor contracts that obligates the vendor to notify you if they are aware of a vulnerability that would impact you and your firm, as well as to cooperate with your investigative efforts to determine what happened and where they need to plug.
Right, and again, sort of with the theme of the day, keeping track of all of your vendors these days and ensuring that they have appropriate security controls in place is just yet another sort of challenge to add to the mix. And so as we're sort of coming towards the end of our time here, I was just thinking to myself that we could talk about this all day. And of course, just last month at the incident response forum, there was a full day discussion on this. But just to kind of fast forward here a little bit, and maybe just some takeaways as we just going to go around the panel here. Just thinking about this hypo and sort of all the attendant circumstances that everyone's dealing with the work from home environment. What is your kind of like one big takeaway from a situation like this? Things that the SEC would be focused on here. Really anything, and we'll give Brent at the SEC the last word, and maybe we'll start with Ken, and if at the end of your thought you want to tell us the best thing you've cooked during your work from home time, go right ahead.
Well, you don't want to know what I cooked, but let's start. Let's start with sort of the big takeaway. I think one needs to look broadly here, not just at the potential SEC exposure, but remember there are other regulators and other regulations that may be at issue at the state level. For example, if you're cross-border, the GDPR obligations as well. So I would think broadly, not just with regards to the SEC disclosures. In addition to that, I would say this is a good learning moment to really look at the incident response plan, your training plan, your escalation plan, and your compliance program generally, because what we haven't spent a whole lot of time on here is the impact of this breach was really a threat to client, not only assets, but also information, perhaps two of the most valuable things that an entity can hold.
John?
Yeah, I think, in this day and age, I think us people working from home remotely, I just think increase the risk of cyber threats out there. I mean, you look at the Voya financial case we mentioned. A big part of the problem with that case was that a lot of the employees or independent contractors of Voya Financial were working remotely, and that made them more susceptible to the cyber attacks there. So I think the risks are higher. The other thing I would try to make sure people keep in mind is that we've been talking a lot about enforcement and OC, but there's also the Division of Corporate Finance, and they are very attuned to the cyber disclosures. We didn't touch too much on public disclosures, but if you look through the comment letters that CorpFin is giving companies now, companies are very aware now that they must disclose risks of cyber attacks, but you'll see comment letters where the Corp Fin folks are asking for a lot more disclosure than what companies sometimes are doing on those risks, including things about describe exactly the costs and the details of cyber attacks, or the board's role in policing the cyber policy. So that's another thing to keep in mind as well. And I'll stay mum on my favorite. I think I tried Chick-fil-A for the first time. So that's been the extent of my dining.
All right, excellent. All right, Brent, you get the last word.
Yeah, I mean, I think one interesting thing is that it gets a lot of attention in thinking about how the SEC's role here in how an issuer makes the decision whether or not to disclose, as if it's sort of an on-off switch. And I think that, what I would really encourage issuers and public companies and sort of lawyers like you and John to think about when you're advising clients is, disclosure really isn't the end of the analysis. There's still sort of a critical question of what are you going to disclose? And I think firms, especially in this environment, right, need to be careful not to just use disclosure as sort of a means to sort of reassure investors that, oh, everything's all right, but to make sure that they're not omitting any material facts about the incident that might make those type of disclosures misleading. And as part of that, I think it's necessary to think sort of holistically about the impact of the incident. So, thinking about all financial impacts of the incident, including, for example, the need to reserve for known liability for state data privacy laws or ransomware payments that they might have had to make. I just think there's a sort of more robust set of information that they need to be sure that they're thinking about whether that's necessary to include. I made cereal for my kids. That's my.
Perfect last word. Thank you, Brent. Thank you, John and Ken.
Thank you, Peter.
Thanks, everybody.
Great job on a really interesting topic. Our next panel is on insider trading. It'll begin at 3 p.m. Pacific. Thanks again to the whole panel. You guys did a fantastic job. We'll be back in just a few minutes at 3 p.m. Thanks.